Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, High-Yield Remedies Core Rules. Let's begin. High-yield remedies issues turn on limits. Most examinees can name damages, injunction, and restitution. High scorers explain why a remedy is available or unavailable. Always ask, is the remedy legal or equitable? What is the measure? Is the loss caused, foreseeable, certain, and unavoidable? Is legal relief inadequate? Would the remedy be feasible and fair? California essays often combine remedies with California claims such as nuisance, real property, fiduciary duty, fraud, contract breach, and community property or business disputes. You do not need a California statute for every remedy, but when punitive damages appear, California Civil Code Section 3294 is a strong anchor. Contract damages limits. Causation. Breach must cause the loss. Foreseeability. Damages must be foreseeable at contract formation as natural results or within the parties' contemplation. Certainty. Amount must be proven with reasonable certainty. Mitigation. Plaintiff must take reasonable steps to avoid unnecessary loss. Liquidated damages. A clause is enforceable if valid under applicable law and not an impermissible penalty. California generally favors enforceability in many non-consumer contexts, unless unreasonable under the circumstances existing when made. Tort damages limits. Plaintiff may recover damages proximately caused by defendant's wrong. Economic and non-economic damages must be proven. Punitive damages require oppression, fraud, or malice and clear and convincing evidence under California law. Comparative fault, avoidable consequences, and statutory limits may reduce recovery. Equitable prerequisites. Inadequate legal remedy. Property right or enforceable obligation. Feasible enforcement. Balance of hardships and public interest. No equitable defenses. Restitutionary theory. Defendant received a benefit. Retention would be unjust. Remedy may be measured by plaintiff's loss, defendant's gain, or specific property traceable to the wrong. Specific performance of land sale. Valid contract satisfying the statute of frauds or an exception. Definite material terms, parties, property, price, and essential obligations. Plaintiff performed or is ready, willing, and able to perform. Legal remedy is inadequate. Land is considered unique. Equitis favor enforcement. No defenses such as laches, unclean hands, impossibility, unconscionability, or unfairness. Negative injunction in service contract. Courts will not order affirmative personal services. A court may enforce a negative covenant not to work for a competitor if services are unique and enforcement is reasonable. California public policy strongly disfavors restraints on lawful profession, trade, or business, so analyze enforceability carefully. The injunction must not effectively force unwanted personal service. Rescission. Grounds such as mistake, misrepresentation, duress, undue influence, failure of consideration, illegality, or material breach. Prompt notice or conduct showing rescission. Restoration or offer to restore benefits received, unless excused. No prejudice making rescission inequitable. Reformation. Prior agreement existed. Writing does not reflect that agreement because of mutual mistake or unilateral mistake plus inequitable conduct. Clear and convincing evidence is often required. Reformation cannot create a new bargain. It corrects the writing. Equitable lien versus constructive trust. Constructive trust gives plaintiff title to specific property or traceable proceeds. Equitable lien gives a security interest in property to secure payment. Constructive trust is preferred when plaintiff can identify property and wants ownership. Equitable lien is useful when plaintiff's funds improve defendant's property or tracing supports a charge, but not full ownership. Lost profits for new businesses. Lost profits are not automatically barred, but they must be proven with reasonable certainty. Established track record, comparable businesses, market data, and expert testimony help. Speculative hopes fail. Reliance cap. In contract, reliance damages may be limited to avoid putting plaintiff in a better position than performance would have done. If defendant proves the contract would have been losing, reliance recovery may be reduced. Election of remedies. Plaintiffs may plead inconsistent remedies, such as damages and rescission, but must ultimately avoid double recovery. Rescission and expectation damages usually conflict because one disaffirms the contract and the other affirms it. Replevin and ejectment. Recovery of specific personal property is different from recovery of real property possession. If the exam asks for immediate return of a chattel, discuss claim and delivery or replevin concepts. For land possession, discuss ejectment and injunction where appropriate. Irreparable harm is not a slogan. Explain why money cannot adequately compensate. A hardship created knowingly by defendant after notice is less sympathetic. Laches requires unreasonable delay and prejudice. Mere passage of time is not enough. Unclean hands must relate to the transaction or equitable claim. Constructive trust requires identifiable property or proceeds. If money is gone and untraceable, seek legal restitution. Do not stack expectation, reliance, and restitution for the same injury. Do not forget nominal damages when a legal right is violated but actual loss is not proven. Use a remedy menu, but tailor it. If plaintiff wants money, start with damages. State the measure and limits. If plaintiff wants action or restraint, discuss injunction or specific performance. If defendant gained from wrongdoing, discuss restitution and constructive trust. If the written contract is wrong, discuss reformation. If the transaction should be undone, discuss rescission. For fiduciary wrongdoing, remedies often include disgorgement, accounting, constructive trust, equitable lien, damages, and injunction. The point is not merely plaintiff's loss. A faithless fiduciary may have to give up profits even if plaintiff cannot prove identical loss. For nuisance or continuing trespass, damages may compensate past harm, but injunction may stop future harm. Balance hardships. California courts may consider relative hardship and public interest, especially where an injunction would cause waste disproportionate to plaintiff's injury. For fraud, consider benefit of the bargain or out-of-pocket measures depending on the governing claim. Punitive damages under Civil Code Section 3294, rescission, restitution, and constructive trust if specific gains are traceable. Conclude by preventing double recovery. A polished remedies essay says, plaintiff may seek these remedies in the alternative, but final judgment should award only one satisfaction for the same harm. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.